Everybody's up. Okay, we're live. We're on TV, okay? So I don't want to watch what you say. Thank you.
report, please. The Honorable Supreme Court of the State of New Mexico.
Please be seated. Good morning. This is S-1-SC-39294, State versus Lobato-Rodriquez. Can I have the entries of appearance, please?
Thomas Lewis, Horton Sales, Lobato-Rodriquez.
Thank you. Mr. Snow, you've reserved 20 minutes for your argument in chief and 10 minutes for rebuttal?
Yes.
All right, you can proceed.
May it please the court, counsel. Defendant killed Connie Lopez by strangling her from behind with a belt while she was strapped into the front seat driving. He confessed to officers at the scene. In a trial, he took the stand and he told the jury how and why he killed her. He received instructions on provocation and manslaughter, and the jury found beyond a reasonable doubt that he committed murder, not manslaughter. The prosecutor erred by mentioning once in opening that defendant invoked his right to remain silent after he had confessed to law enforcement. And instead of engaging in the detailed and context-specific inquiry that the law requires, the Court of Appeals essentially treated this as per se reversible error.
Wouldn't it be easier to give guidance to trial lawyers to have a per se rule in opening arguments? Like, just don't do it. It's not the same. I think it'd be complicated to have a rule like that in examination because you can't often predict what somebody's going to say in response to any kind of question. But opening is particularly constrained, and it's fully within the attorney's control. So why not have a per se rule that is just out of bounds no matter what? Comment on silence in your opening.
Yes, Your Honor. So I think there are a few separate points to that. The first is, although it may be easier to administer, that would come at a really high cost because we would essentially, in cases like this where it is harmless, require a whole new impaneling of a jury.
Wouldn't it likely not happen then if we just declared this bright line rule like, hey, y'all, don't do this. There's great penalty if you do this. Because, openings are prepared. They're thought about in advance. So then it would beg the question of, being a harmless error, and it would turn into something that would be more akin to intentional conduct by an attorney. So why not have that bright line rule? You know what my question is.
Yes, Your Honor, I believe I do. And if I get off track, then,
yeah.
One rule is that this court would have to overrule Gutierrez to do so. Another reason is that, as Your Honor pointed out, we treat some comments on the right to remain silent differently, depending on when they happen in trial, like in testimony, because sure, who knows what witnesses say sometimes. But also in closing, this court engages in an inquiry where it considers, well, was it a direct comment or was it an indirect comment? Would the jury naturally take this as a comment on the right to remain silent? Was it isolated? So I think to treat them completely differently wouldn't make a great deal of sense to have three different rules depending on what.
Why would we be reversing Gutierrez?
Because this court, that would involve a comment on the right to remain silent in opening, and this court declined to adopt a per se rule of reversal, even though it happened in opening.
But Gutierrez was replete, citing this out-of-state this driver case, that the time you don't, to the Chief Justice's point, the time you don't do this is opening statement. And it seems the Court of Appeals seem to suggest, as Gutierrez does, and driver was plain error, it looks like, but there's no harmless error analysis, so you just can't overcome it. I mean, it's not just designing a rule, but there's a reason, it seems to me, in Gutierrez behind that, which is opening statement is you're announcing what the evidence is going to be. It's not closing argument. Jury, you're going to hear this. As a state, I'm going to put on evidence. And when you say it in opening, that jury, the first thing they're hearing is, I'm going to hear throughout this trial. So it's so bad, there's just no harmless error that can overcome it.
Yes, Your Honor. So I think the fact that the Gutierrez court knew about this issue, knew how prejudicial a comment could be in opening, and still declined to adopt a per se rule for opening, I think shows that this court squarely considered it, and defendant hasn't made any of the showing that's usually required when this court thinks about overruling well-settled precedent. And just to touch briefly on differences between opening and closing, in the state's brief in chief, I put the prosecutor's statement as a block quote. And I think it's worth reading because it gives kind of the flavor and the context of the prosecutor's statement. There are ums and ahs. There's seeming to get somewhat sidetracked. So this really doesn't seem like this was just getting up there and sitting and reading a prepared statement, and it certainly doesn't seem intentional.
So you're saying the context. So when Gutierrez says that we're supposed to look, one of the things we're supposed to look at is the context in which this error was made. You're saying the context is the ums and ahs, or is the context that it was made an opening statement when you're framing your case and you're not supposed to refer to anything that's not going to come into evidence?
Yes, sir. I think the fact that the nature of what the prosecutor was saying can inform the context. I think other very relevant contextual inquiries are the fact that this was a single statement. Nowhere else in the trial was this at all referenced to. More contextual things was the defendant had waived his right to remain silent earlier in the case when talking with law enforcement. At trial, it appeared to always have been the defense's plan to put the defendant on. So he's going to waive his right to remain silent. So if we're looking at the total continuum of comments on right to remain silent and how impactful they are, the state's not trying to minimize this or say it's good and that the prosecutor should be encouraged to do this, but this is on the lower end of the spectrum when we, just from the outset, just based on comments.
Counsel,
Yes, sir.
to follow up on some of the prior questions, you know, if you didn't learn it in high school civics class about the right to remain silent, it should not be commented upon. You might have learned it in government class in college. You certainly should have learned it in first year of law school, and you should have certainly have learned it in getting your training as a prosecutor. I mean, this to me is tantamount, if it's not in fact intentional misconduct. In the brief here, you do quote him, in your brief, you do a block quote of what he says, but you also say on page 6 that the prosecutor explained that he had made a factual statement and that it had not been my intention to comment on defendant's right to remain silent. Well, it sounds to me like this was very intentional because he was ready to say, I'm making a factual statement. I'm not commenting on this. You know, that's not my intent. But when the minute it seems to me that this is so basic, fundamental a rule of law that we have in all the courts of the United States, that why should it not be deemed to be intentional? And as the chief said, the cost, if you do it in opening, is per se, and you're going to get a new trial. Why should that not be the result?
Yes, Your Honor. So I think a couple points on that. The state respectfully disagrees that the record shows this was an intentional statement. The prosecutor made that comment that Your Honor highlights after there was an objection, after defense said this is error per se that requires reversal. So the prosecutor was telling the district court what happened. I don't think that discloses any sort of premeditated intent. As to the larger question about why shouldn't this, as the policy, be error per se, again, this court would have to overrule well-settled precedent without a showing that's normally required, but it was wrongly decided that things have changed. And I'm not sure that the state would agree with Your Honor's assertion that in every court that this would be a per se rule requiring reversal. I think New Mexico would be, I'm not prepared to answer right now, but I think that would be an unusual rule. I think the majority rule is by far harmless error.
So let me ask you, because I'm trying to think of one in my head. Do you know of any other automatic reversal rules in the criminal law? And I'm trying to think of one where things are inadvertent or unintentional? That's my first question. And then second is, there's a lot about the opening statement, which I always remember the saying right before they start their openings, literally to every jury. What is said in opening statement is not evidence. It is simply the attorney's opportunity to tell you what the evidence will show. We also say that before closing. Why is it not, to me, if there's an automatic rule, why wouldn't it apply to closing too? That's kind of the last chance for the person to talk. It's really hard to rebut that once that's done. And if we have an automatic rule. But really, to me, the evidence is what juries pay so much attention to. That's just harder because you don't know what the witness is going to say, and it could be the witness. So I'm just wondering if there's an automatic rule, why it wouldn't apply anytime it's initiated by the prosecutor as opposed to a witness. But then also, do you know, I just can't think of another automatic reversal when something's inadvertent or unintentional, where we don't do a harmless error analysis because where we don't treat each case on a case-by-case basis.
Yes, Your Honor. Yeah, that's a good question. Standing here, I can't think of one offhand, certainly for unintentional. Certain things, certain events in court, like, a witness against the defendant physically not being in the courtroom, you could say that's a per se computation. Sorry, you reverse. But as for statements, especially when there's indicia that it's unintentional, I don't believe so. So this would be an outlier rule.
We've talked about the timing of the statement. And to me, it's this bears on the harmless error, whether it's opening or closing, all fair points. I'm wondering about, so the defendant does take the stand. The Court of Appeals, part of their sort of bright line rule is that we agree with defendant that his credibility was crucial since he testified at trial and the element of provocation was at issue. And I'm wondering, with regard to the provocation in particular, what it was about this statement and opening that it would impact. I mean, he said he did it, right? What is your position on his credibility with regard to this provocation defense?
Yes, you're right. I think that's a very important point to highlight because functionally the Court of Appeals was treating this as a per se rule. And if you look at it, the implication is anytime a defendant testifies and it bears on anything that's disputed, which is going to be something at trial. So as to how this comment bore on provocation, I'm not so sure. It's easy to imagine some circumstances where a comment on the right to remain silent could bear on credibility and could affect. So for example, if some witnesses had told the jury that the defendant killed Connie Lopez in a very premeditated way, and if defendant's story was very different and he said, I killed only as a result of adequate provocation, and then if the prosecutor said something like, well, he's telling you a story now, but he didn't tell that to the police, there's a clearer relationship. That's implying the defendant's account now is not to be trusted, and that would bear in a very direct way on his defense on provocation. But here, it's much harder to see that connection. The state didn't go so far as to say this wasn't the comment. This would have no effect on it. But again, when we're looking at the whole continuum of comments on the right to remain silent, that's another contextual factor that brings it to the lesser side in this particular case. So it seems that New Mexico courts are rightly very concerned about the right to remain silent. I think it's important to emphasize that reversal and creating a bright line rule overturning precedent that would potentially make New Mexico an outlier state is not the only tool in this court's toolbox. For example, in State v. Torres, there the prosecutor in closing, this wasn't a comment on silence, but it was prosecutorial misconduct. The prosecutor in closing called defense counsel a liar, and then referring to a disputed piece of evidence as to whether it existed that had never been introduced. The prosecutor walked over to the counsel table, waved around a piece of paper before the jury, implying that it did exist. So this court upheld the denial of a mistrial. The defendant's conviction could stand. And then the court issued a published opinion differing from the Court of Appeals, which resulted in a memorandum, issued a published opinion that fully laid out why the prosecutor's actions were improper and what prosecutors, when they're pushed by defense counsel, when they're in similar situations, should do. So creating a new bright line rule is not the only option that this court has.
So you're suggesting engage in harmless error and chastise prosecutor for making the comment in the first place, but hold that it's harmless. That would be your path to resolution.
Yes, Your Honor.
Well, they were chastising Gutierrez and it didn't help. I mean, severely. And apparently haven't read Gutierrez because there is 2 paragraphs on it.
Yes, Your Honor. So it is worth pointing out that that decision was decided in 2007 and this trial occurred in 2020 or so. It was sometime during the pandemic.
I don't mean to beat a dead horse, but given the fundamental nature of the rule, how can you ever say it's inadvertent? Isn't it more appropriate to say, I presume it's intentional. Now you tell me, you prove to me why it was inadvertent. Because, I mean, parsing words to say it was not my intention, what I really was doing was a sequence of events. Well, the sequence of events included in him invoking his constitutional right to remain silent. How? I mean, even television, anybody watches television, any crime show knows you can't do that. So why should we give the benefit of the doubt to the prosecutor who's had all this training, law school, et cetera, and say, well, it's inadvertent. We're just going to engage in harmless error.
Yes, Your Honor. So I think a few points. I think because this court other times does consider like that, like when there's a statement on the right to remain silent made in closing. And again, although there's more likely that an opening is going to be prepared as opposed to closing, besides that, there's not a very large conceptual difference between the two. So again, this would be overturning precedent to create a very particular rule. And also it would move away from kind of the conceptual framework, the harmless error analysis, and how this court has looked at comments in opening is gauging its effect on the jury. So then that would turn the inquiry into what did the prosecutor.
But the problem with that is, like we say all the time, the jury questions and how demeanor of the witnesses and how things are played out in court are there at the court at the time, whereas on appeal, we have nothing but a cold record. There's no way, we're hampered of at least 50% or more of the available evidence to demonstrate whether it is or is not harmless.
Yes, Your Honor, and we are dealing with a cold record here. The trial judge wasn't dealing with a cold record, was there, heard both openings rather, was well positioned to make that sort of inquiry and let the trial go forward.
Well, and even if couldn't, in any particular case, the court on review could find that it was intentional, but limited to in the nature that it is here, and nonetheless find it's harmless error. Could those two things exist at the same time?
Yes, sure.
Is there any case law that says if it's intentional, it is by definition not harmless error?
Not that I'm aware of. I think it's probably it's part of the overall contextual flavor. So, but as to whether it's a determinative factor, I'm not familiar with anything. And yeah, so I think that's a point worth highlighting, Your Honor. I think here it helps inform the effect, but the question is always the effect that this would have on the jury.
And likewise, if the comment had been, in opening statement, you're going to learn how outrageous the conduct of the defendant was. He invoked his right to remain silent because he didn't want to cooperate in and that kind of would certainly be different contextually than the comment here.
Yes, Your Honor. And that's a fair point. That again goes back to the spectrum of comments on the right to remain silent. The Court of Appeals would just treat them all the same, but there can be clear differences in effect. And if we do look to the prosecutor's intent culpability between different circumstances, that's why this court requires a nuanced contextual analysis. So I'm running low on time. If this court does not adopt a per se rule that a comment is in opening is per se reversible error. If this court does not do that, then there must be a universe of cases where an error is harmless, where the state can satisfy it. It's a demanding standard, but can satisfy it. It's the state's position that this is one of those rare cases. It's going to be a rare case when the defendant knows he's going to testify from the beginning, testifies, and as the district court put it, testifies he committed murder. This is a rare sort of case. And if this case does not satisfy the harmless error standard, it's a difficult question. What case would? Perhaps it's possible to imagine some sort of very exotic set of circumstances. But if that's so narrow.
Can I respond to your question?
Yes, Your Honor.
So you make the comment to call into question the defendant's credibility, that is that don't believe anything he says, because when he had a chance to say something, he invoked his right to remain silent. So don't believe him today, anything he says.
Yes, Your
And that would be a motive for doing it at the front end, just knowing he's going to testify, to say, when he testifies, don't believe anything he says.
Yes, Your Honor. And under harmless error standard, that should be a reversible error. If there are no further questions, the state respectfully requests the court affirm its convictions.
Mr. Lewis.
May it please the court, counsel. I would like to expand a bit on the question that Chief Justice Bacon began this argument with, which is, why is there this even before this court? If the state's error is intentional, it's not inadvertent. There is a line of cases that do make that distinction, that if the error is, for example, the kind of inadvertent reference to a constitutional violation when a witness makes a statement that was not elicited by the state, this is not that case. Everyone who has ever tried a case to a jury knows that the opening statement is your chance to make your best case to the jury, to provide the jury with a roadmap of where you expect to go. And of course, you are going to put your best foot forward. You are going to highlight facts and issues that favor your case.
Why would we not just have if we're going to have a per se rule, in my mind, if we think this conduct is so outrageous, why not have one anytime a prosecutor initiates it? To me, it would be outrageous if the prosecutor asked a witness, did you contact the defendant? Knowing the officer did. Yeah, I called him. And then well, did he agree to speak with you? I mean, then you're eliciting actual evidence. To me, that's just as much of a no-brainer, if not more. So I just don't understand why we would have a per se rule. If the conduct is so egregious, why not just apply it anytime a prosecutor initiates, whether it's the admission of evidence or a comment?
Because witnesses quite often say things that you don't expect them to say.
And that's why I'm saying it would be the prosecutor initiating it. Absolutely. You never know what's going to come out of a witness's mouth. But if the prosecutor asked a question that was eliciting testimony about the defendant's silence, if they caused it, why, or if it said in closing, I mean, if the prosecutors are supposed to know this rule, I just don't understand why the per se rule wouldn't apply throughout the entirety of the trial.
Because in the situation that Your Honor has just described, the goal of the question is not to violate the constitutional rights of the defendant.
Or what if
It's
it said,
to elicit-
okay, what if he said, you asked the defendant to speak to you and he didn't, right? Then is that,
Objection leading.
well,
There are tons of objections that could be
there's
made
always,
to that
but
question.
sometimes they don't object. So I'm just
I'm
saying,
aware.
I'm asking if the prosecutor initiates the conduct, why not just apply it all? Because if they're supposed to know this rule and it's always intentional, why not apply it? I mean, that makes it more straightforward to me. Prosecutor, you should know that you're not supposed to comment on silence. So if you do it at an opening, closing, or you initiate it from a witness.
Well, if the question were phrased in the way that Your Honor has just proposed, clearly it's intentional because it's designed to elicit
I think I'm actually asking you to expand this per se rule you're asking for, but I guess we'll leave it to opening.
well, because trial is a real-time experience. If you're examining a witness, you don't always get the response that you are expecting. So I think there's much more of a gray area in that context.
Okay.
But in the
So are you
context,
asking us to overturn Gutierrez?
no, I'm not. In the
Why
court,
not?
there is a path to resolving this question that does not require this court to do anything at all to Gutierrez, and that is simply to quash cert. Gutierrez,
The problem with that is the Court of Appeals, I mean, that last paragraph is, do you agree or disagree? That is a bright line statement.
That's in violation of what's in Gutierrez.
Yeah.
So we can lay silent and then create even more confusion for judges and trial attorneys as to what the rule is if we quash.
but it's a non-precedential opinion. So it
Oh,
doesn't.
I wish those don't. I wish those didn't get cited to us, but they do. I know. I get what you're saying. Is it's not, it's not declaring anything that's new, but I think that invites even more confusion on this. But let me turn you to a different question, and it's picking up on something that Justice Thompson asked Mr. Snow. How does this particular comment on silence bear on credibility as it related to provocation? I'm struggling to connect those two concepts.
There are several ways. The court instructed the jury on first-degree murder, second-degree murder, and voluntary manslaughter. In order, the jury convicted on second. In order to reach a verdict on second-degree murder, the court had to find that there was no provocation, since that's part of the instruction.
Mm-hmm.
So it is not possible to say on the basis of a cold record that the jury did not have in the backs of their minds the comment on silence when they were deciding that Mr. Lobato-Rodriquez's account of what happened proved no provocation or provocation.
But I think the law, as it's crafted right now, requires something more than that. Or you would undercut the harmless error analysis. It wouldn't exist if that were true, because then every comment on silence would undo every portion of a defense, no matter its relation. So assume with me that the court stands by the harmless error analysis. So if that happens, how does this particular comment bear more specifically on provocation?
The jury had to believe that a reasonable person in the circumstances in which Mr. Lobato-Rodriquez found himself would not have behaved in the way that he did. There is an element of reliance on the believability, if you will, of what Mr. Lobato-Rodriquez told the jury when he was recounting his experience. And
I'm sorry, counsel, can I stop you there? From the record, though, what he said was the provocation was a statement about mountains. And my understanding is that just words are not provocation. So isn't there an issue there that even if we take and completely believe the defendant in this matter, don't we have an issue right there?
Actually, there is case law that holds in New Mexico that their words alone can constitute provocation if they are informational words and if there is a course of conduct that gives an additional meaning to those words that are spoken. In the case that says that is State v. Sells. And also, I think I would
But here, looking at the defendant's testimony, taking it at its face value, there is no. I really question whether the provocation instruction should have been given at all in this case. It's a challenging place to get. But I still really wonder, if we take at face value everything he said, how this comment undercut idea of provocation, given what the record looks like.
There was a series of events that lead up to the killing of Ms. Lopez. First of all, Mr. Lobato-Rodriquez is traveling with a person that he does not know. He knows that Ms. Lopez knows that he has a large sum of money because Ms. Lopez translated for him at Wells Fargo in Florida. So he is traveling to the border. He is from the border region himself. So he knows that the border is a region rife with murder and kidnapping. And there's other events that lead him to believe that he is in danger.
The victim's not the source of those events, it's those other unnamed men. And the border, I mean, he's the one who asked to go there. The border being dangerous and stuff, does that mean anybody's going towards the border and it being dangerous then gets to have that fact as part of their provocation?
Well, not everyone who goes to the border is traveling with someone they've never known before and traveling with a large sum of money from his cash settlement in Florida. So he has an extra element of risk. He also knows that his daughter is involved in this because Connie Lopez has specifically changed their itinerary so that they can rendezvous with the daughter, which creates an idea that there may be some kidnapping.
Justice Bacon's question, again, I can see if he said, I didn't do it, and that bearing on credibility. But maybe you don't acknowledge those are two different things, from saying I didn't do it and he said, well, I did do it, and saying I was provoked. Because unfortunate for you, we've had a week of provocation. Okay? And one of the things is reasonableness. So what we're asking is the jury very well could have accepted as true the mountains, going to the border, all those things. So it's just not reasonable. It's just not reasonable. It's not bearing on the credibility of what you decided to say when you took the stand. We're just not buying it.
But the first thing that he said to the Border Patrol, I believe, was, I had to kill her because she was going to kill me and kidnap my daughter.
But what the evidence, as I understand it, is he choked her with his belt from behind while she's strapped in a seatbelt for 20 minutes, and then decided to go ahead and kill her, and that's when he killed her. How is choking somebody with a belt of somebody strapped in a seat with a seatbelt, how is that provocation? I mean, provocation to me is like you react. This sounds like just a cold-blooded murder to me.
During the 20 minutes that he had his belt around Connie Lopez's neck, they were arguing, and he was trying to get her to say, and she did not respond to his questioning, that she was not in league with the border cartel, the people who were in the pickup truck that he believed were following them.
If I'm being choked from behind with the belt, I'm not sure I could respond to somebody's questions. I don't think we can question the victim's lack of response as then creating some additional provocation.
I kind of wonder why the instruction was given here as well, but I mean,
But here we are.
Once the instruction is given, the jury is being asked to consider it. And so if the question is put to the jury, the credibility of Mr. Lobato-Rodriquez is something that they are allowed to consider as well.
Or they can just compromise.
Well, who knows? We can't say what goes on in the jury room. But it is out there. The question has been given to the jury. Once the jury has the question, you can't take the question away from the jury and say, oh, jury, we know better than you. You couldn't possibly find this.
And let's assume we keep the very high standard for constitutional errors of harmless error. In my mind, that's a really hard standard for the state to meet. Other than this case, I can't think of another case where the state would meet it. And I'm wondering why you think, and so, because I wanted to preface that, I think it's a very high standard when it's a constitutional error. But why do you think the state has not met it in this case?
Don't we want the standard to be as high as it possibly can be? This is a precious constitutional right.
Why do you think the state has not met it in this case?
Why is this not harmless error?
The harm is not only to the ability of the jury to take Mr. Lobato-Rodriguez's statement without the element of the exercising the right to silence. It is also a harm to the process of a fair trial. This court has been chastising the state for over 20 years for doing exactly this same thing, most recently in Gutierrez and McDowell, and in a line of cases going back into the 90s. The state is going to continue to do this unless this court forces them to stop doing this.
What other states,
Otherwise, they're
what
going-
other states have adopted a bright line rule about comment on silence?
I can't give this court any.
I'm going to ask you just one more time because I'm asking mostly because it's just, this is where I really am, I want to hear your response. Why is this not harmless error based on the facts and the record of this specific case? Assuming we don't adopt a bright line rule and we look at it under our current analysis, what can you point to in the record that would convince me this is not harmless error?
Because, among other things, I'll begin with pointing this court to the fact that Mr. Lobato-Rodriguez invoked the Fifth Amendment after he made a voluntary statement to the Border Patrol saying, I killed her because she was going to kill me and kidnap my daughter. And then when he's taken to Deming to be interviewed by the New Mexico State Police, only at that point does he say, I'm going to be silent. So the jury is given sort of a two-faced impression of Mr. Lobato-Rodriguez. He's shifty. He's manipulative. He says different things to different people depending on what he thinks they can do for him. So that's another, in addition to the mere evocation of his constitutional right, it undercuts his believability because he is not consistent.
So do you agree? None of that was said in the Court of Appeals opinion. It seems kind of thin on analysis to me.
Well, the Court of Appeals looked at this court's opinion in Gutierrez and concluded, I believe rightly, that no more needed to be said. Basically, what they did was adopt Gutierrez almost line for line. So,
Except the result.
except for the result.
Prosecutor's comment, line 1, 2, and 3 of page 4 of the opinion. The prosecutor's comment tainted the jury's view of the evidence from the very onset of a trial in a way that cannot be undone. That to me is saying, forget about harmless error. Then the next sentence, under the circumstances, a prosecutor's comment cannot be regarded as harmless error beyond a reasonable doubt. That is not Gutierrez. As a matter of fact, that's not, well, not as a matter of fact, it's a matter of law. It's also not Driver, which Gutierrez relies on. I mean, Driver goes through a plain error and it's cumulative. But you can tell me that's Gutierrez, but I don't see how it is. It's a new rule.
Well, with all due respect, Your Honor, why should not this court adopt a bright line rule? What else is going to stop the state from continuing to abuse the right to remain silent? Previous statements by this court have not had that effect.
I totally appreciate that. I really do. The problem is, if we do that, we've gotten rid of harmless error. It's the reverse, right? We've abandoned our harmless error analysis, and we've abandoned it because of when the statement was made. And it's not clear in writing that rule why the timing of the statement necessarily impacts it. I mean, we can announce a rule, and I agree 100% that we've told them several times not to do this. We see it all the time. But to announce a rule like this, it's not as simple as that.
Well, with all due respect, Your Honor, the court could limit the rule to comments made in opening statement.
But then that goes right to Justice Mora's observation of, isn't it even worse to do it in closing where there's no then opportunity for any kind of rebuttal, and it's the last thing they hear before they go in the jury room? And then it begs the question of, then do we have yet another rule or a difference in rule when the error is clearly invited by the prosecutor as opposed to inadvertent, uncontrollable witness problem? So are we just going to say all comments result in a mistrial or a new trial, one of the two? Or is it something different? And is that actually what you've asked for in your relief before the court here too, which I don't think you have, because your goal is just to quash and live with what the Court of Appeals has said, regardless of the outcome for the trial courts.
That is correct. But if this court feels the need to announce a bright line rule, I would distinguish the situation that Justice DeMora has discussed with an opening statement. And for this reason, an opening statement has a special character, a special quality to it. It's the first thing the jury hears. It has more of an impact on the jury because at that point in the trial, they know nothing about the facts, they know nothing about the personality.
But casts a pallor on the whole proceeding.
Exactly, and I would just call the state's attention to what the Third Circuit had to say about this when they compared it to a tainted opening statement is like putting a drop of ink in a glass of milk. Once it's in there, you can't get it out.
So let me ask you this though, but isn't the purpose of a bright line rule to stop the behavior by prosecutors? Because and if that's the purpose, because it's like you said, we've told them, they haven't listened, or whatever, for whatever reason. If the purpose is to deter the behavior, then why are we saying, well, if you do it in opening, it's automatic, but if you do it in closing, then we're going to do harmless error? I mean, if the whole purpose of the bright line rule is to deter the behavior, why not apply it anytime a prosecutor initiates it?
Well, if the court wishes to do that, certainly the court can do that. But again, I put an opening statement in a particular category of its own because of its primacy, and also because an opening statement by trial counsel is always made with premeditation. You think about it, what do I need to say to get their attention, to make them see the case?
Your bright line rule focuses on the effect it has on the listener as opposed to the deterrent effect, and that's what harmless error analysis is.
But if the court relies on harmless error in the future, then that puts us exactly where we are today. That is, the state can always say, oh, it's harmless error, oh, no rational jury could have been affected by this, and go on their merry way and go on commenting on the right to silence. This court has said on many occasions before this that this is not an error-correcting court, this is a policy-making court. So if the court takes exception with language in the Court of Appeals opinion, it doesn't have to correct the error. But if the court were to announce a rule, it would be making policy that would give an additional layer of protection to defendants in New Mexico, because up to this point, none of this court's efforts to prevent continuous references to the right to silence have prevailed on the state.
Mr. Lewis, has any argument ever been made that the state constitution under our interstitial approach provides greater protection than the federal?
Yes, the issue was raised by trial counsel. And so
Was it raised on appeal?
I would have to consult my brief momentarily if you'll give me a minute.
Was it merely raised below, or did they explain why it would provide more protection? Was it actually preserved?
It was preserved in the arguments that were made by trial counsel. The trial counsel was very persistent. He made the same argument repeatedly through the course of the trial, first when the comment was made and again at later points. Well, without unduly wasting the court's time, I can't point to a specific location in my brief, but I know that it was argued in the trial court below. Although it was not referenced, I think, in the Court of Appeals opinion. But I would urge this court to take that into consideration, into the fact that New Mexico does give greater protection to defendants. And this would be an opportunity for this court to reinforce that protection, to prevent the state from continuing to do what it's consistently doing. And if there are no further questions, thank you, Your Honors.
Thank you, Mr. Lewis.
Thank you, Your Honor. So to begin with, this court certainly is a policymaking court, and why it's appropriate to hear and decide this case is because the Court of Appeals departed on effectively a different policy from the one that this court has announced. That's part of this court's role, to keep New Mexico courts following the policy it sets. As to the question of whether we could engage in the interstitial analysis, we're here at the rebuttal on closing argument and the Supreme Court argument, and the parties have never substantially crossed swords on this issue. So to the extent the court is interested in this issue, seriously considering it, the state would respectfully request the opportunity for supplemental briefing, especially because this would probably be a great outlier. Moving to the bright line rule sort of requirement, if this court were to adopt it to the right to remain silent, it would seem to make sense to apply it to other, very well established constitutional rights. So then we will have gotten rid of the harmless error analysis, not just for substantial parts of comments on the right to remain silent, but for other constitutional rights. And if the internal logic of it is, well, this is just such a well-established rule that every prosecutor ought to know it, then it seems like it would actually require going further. And under Bright, State v. Bright, potentially barring retrial because it caused reversal. That inquiry is purely objective. Any reasonable prosecutor could be expected to know it, and it did, in fact, cause it. So,
Mr. Snow, can I ask you a question? Let's assume voir dire, and the question is asked of the veneer. Can anybody believe a defendant who testifies who invokes their right to remain silent when they're questioned by the police? And nobody answers yes, or whatever the situation is. If somebody says yes, they're kicked off, but everybody remains silent. And then the jury, when they're sworn, say that they can follow the evidence and the law. Is there any way to correct that flagrant violation?
So it would have been the prosecutor that was asking?
Prosecutor asking that question in voir dire.
Yes.
How would you correct that?
The defense could request a mistrial, and it'd be up to the discretion of the trial court who's sitting in voir dire.
There's no trial, hasn't started. Jeopardy hasn't attached.
Well, yes, Your Honor, and that would potentially address a Bright problem, but it would, under a prosecutorial misconduct or
There's no trial to mistrial.
I believe, this is just me speaking, I haven't researched and briefed the issue. I believe the district court could discharge the veneer panel and impanel a new one. So I think that would be the remedy. So once we start looking at the bright line rule, the more and more complicated it becomes, the more clear it's implicating very different areas of law and upsetting well-settled precedent. In this, a couple of justices on the court mentioned, thought out loud, why was a provocation instruction given at all? That's a fair point. I think that this could be a case where they didn't have to give it as a matter of law. It appears that defense counsel, in arguing for jury instructions, said you have to, because you've instructed on second-degree murder, and use notes suggest it's a lesser included offense, you need to give it.
In the harmless error analysis, if that's the way we go, it's not with regard to the murder. It's with regard to this, actually, it's this question of provocation. I think defense counsel makes a good point. What, as part of that analysis, does it play any role in whether or not this instruction should have been sustained or been offered to the jury as far as a harmless error analysis on provocation?
I can't see directly. I mean, I think it cures any potential that this somehow foreclosed an avenue of defense. That he was given an instruction that legally he may not have been entitled to, I think just kind of further shows that this wasn't the prosecutor's one comment in opening that facially had nothing to do with the instruction he ends up receiving. It just kind of further shows the disconnect and further shows that it was harmless. So in talking about the harmless error standard, this my friend on the other side referred to Gutierrez and McDowell, and those are cases where convictions got reversed under the harmless error standard. In fact, there aren't many reported cases in New Mexico where it's been found that a comment on the right to remain silent is harmless error. So there isn't really a suggestion that the harmless error standard is letting troubling convictions go or is too lenient. So again, that kind of bears on where this court draws it as a policy matter.
Counsel, I guess the question I have is that one of the statements that is made by defense counsel is this is the third time this has happened. All the other ones, were, but this is continuing to happen. So in a harmless error situation, we're still seeing the same behavior that was mentioned by Justice V. Hill. You learn from TV not to do, let alone law school. So I guess the question is harmless error, if that's the standard and it's not working, is it a bright line rule, at least in opening something that should be considered?
Sure. So the state submits that in terms of a deterrent effect, because harmless error is so very difficult to satisfy, the deterrent effect of the rules is going to be pretty similar. I think even if you adopt a bright line rule, it's still going to happen sometimes. Prosecutors going to be giving opening extemporaneously. Words will get away from them, and some will come out you wish you could take back. And the only difference between those worlds is that, it's just very easy. The Court of Appeals just has to do a 6-paragraph opinion versus a harmless error standard where you're still, in most cases, going to reach the same result. It's just you carefully analyze it. And to satisfy the harmless error standard, that's proving there's no reasonable probability that the error impacted the verdict in this case. And the state respectfully submits that this is one of those very rare cases because of its unique facts and circumstances. Unless this court has further questions of me, the state respectfully requests that this court reverse the Court of Appeals and reinstate defendant's convictions.
Thank you, Mr. Snow. All right, counsel, thank you for your presentations today. It was an interesting conversation. And now the court will be in recess.